Hello, everyone. My name is Ron Weich. I'm the Dean of the University of Baltimore School of Law, and I am very pleased to welcome you to the latest installment of UB Law in Focus, this online discussion series in which we discuss important legal issues with members of our faculty and alumni and friends of the law school. This afternoon's webinar will look at the life and legacy of the late Supreme Court Justice Ruth Bader Ginsburg, who passed away at the age of 87 less than a month ago on September 18th. And over the next hour or so, our three very knowledgeable panelists will share their thoughts about the impact Justice Ginsburg had on our legal system and our society as a kind of cultural icon. We'll look at the battle currently underway over the president's nominee to fill Justice Ginsburg's seat and what that may mean for her legacy. We are looking forward to your questions, which you can submit using the Q&A function on your Zoom dashboard, and we'll get to as many of those questions as we can. And before we begin, and before I introduce our panelists, I want to tell you about our next webinar in this series. On Tuesday, October 27th, we will be discussing the topic of recognizing the Black family, structural racism's obstacles to kinship, wealth, and prosperity. So you can learn more about that webinar and register for it on the UB Law website. And now for this afternoon's discussion. We have three panelists, all of whom are UB Law professors. So we're staying in the family for this discussion, and I'm very pleased to be joined by three of my colleagues. Professor Margaret Johnson is the law school's Associate Dean for Experiential Education. She's also the director of the Bronfein Family Law Clinic and co-director of the Center on Applied Feminism. Dean Johnson has been on the UB Law faculty since 2006, although this semester she's a visiting professor at the American University Washington College of Law. Professor Dionne Koller is Associate Dean for Academic Affairs at UB Law, where she also directs the Center for Sport and the Law. Dionne also joined the faculty in 2006 and teaches civil procedure and is a noted scholar on legal aspects of Olympic and collegiate sports. And finally, Professor Phil Closius joins us. Phil teaches constitutional law and sports law. He's been on the UB Law faculty since 2007, and he was the law school's dean. He was one of my predecessors from 2007 to 2011. Phil is also a very successful appellate litigator and brings that perspective to this discussion today. So thank you, panelists. And thank you, guests, as well, for joining us for what I hope will be a lively discussion. So Ruth Bader Ginsburg, let's first note that she was, at the beginning of her legal career, a law professor. She began teaching at Rutgers Law School and then eventually moved to Columbia Law School, where she taught, among others, Professor Closius, who at that time was just plain old Phil. Okay. What was Justice Ginsburg, what was Professor Ginsburg like in the classroom?
She was probably the most thoughtful person I've ever met. When you asked her a question, she wouldn't respond. There would always be a silence. I mean, it could be a question like, you know, hey, where's the bathroom? And she would stop and reflect on it. When she visited us in Toledo, we had a cocktail party, and the Toledo lawyers went crazy because they asked her a question. They keep thinking she hadn't heard them, and she would have to politely say, I'm still thinking of an appropriate response to you. She was one of the smallest people I've ever met. She was 4'10", about 95 pounds. And again, when I had her in Toledo, I said, boy, I bet there was a lot of macho male lawyers that underestimated your skills and you just destroyed them. And she smiled and said, yeah, that happened a lot. And I said, oh, okay, that's what I would have thought. The two things I remember most about her class, and I'm cheating here because I'm actually nerd enough to have kept my class notes from her class. But I did look back, and you know, the women in the class thought she was a feminist, and she constantly said, I don't know if I'm a feminist. I'm really for people's choices. I'm really for the government staying out of and not forcing people to do stuff. And I always thought that was interesting. And the second thing that she highlighted a lot was that she was against presumptions in the law, and that the biggest presumption in the law was the dependency of a wife on her husband. She did a lot of things telling women that in order to be truly equal, they had to forfeit presumptions that favored them. And that was a surprise to a number of the women in the class, I remember. But she did always say, that you had to avoid presumptions, stereotyping, and kind of individual freedom. That's were the things that came out most. I can also
was she a tough grader? Was it a tough course?
She was. I'm still bitter that I didn't get an E in her class. I got a G. So I will say she was a tough grader.
Let me open it up to both Dionne and Margaret. Do you see any of the law professor in her work as a judge and then a justice? Did she bring some of the academy to the bench? Dionne, what's your thought on that?
Well, as a civil procedure teacher, her opinions are ready-made for teaching. The clarity is really unmatched, especially in areas that were previously a mess, like personal jurisdiction. But she famously said in a speech that she brought the civil procedure teacher with her to the court, and she saw her opinions on jurisdiction and procedure as still trying to teach procedure, that she wanted them to be used that way. She knew that in a lot of the doctrines that she was trying to clean up and bring greater clarity, she needed to teach the lower court, she needed to teach her colleagues, and certainly she knew that generations of law students would be taught as well. And so I think I see that every time I teach her opinions. They are ready-made for learning and understanding, and it's something that I really appreciate about her work.
And Margaret,
one of the things I was just going to comment on that. One thing that I thought was interesting is that when she was at Cornell as an undergrad, she was taught by Vladimir Nabokov in English. She was taught how to write, and she was an excellent writer. Her clerks would talk about famous battles over words to be used. And so clarity and precision was very important to her. And in reading more material, there's a wonderful tribute to her by the former ACLU executive director who hired her for the Women's Rights Project. And he talked about when she first argued before the Supreme Court for Frontiero, and we'll talk more about that case later, I'm sure. But when she did, the justices were all mesmerized because her argument was so cogent and clear that not a single one even asked a question. They were almost dumbstruck, is how he related. So I think she brought that clarity, precision, cogency, thoughtfulness that Phil was just talking about to her oral and written advocacy and work.
Well, I do want to talk about her opinions and her work as a litigator and then as a judge, but let's stick with Ruth Bader Ginsburg, the person, for the moment. Margaret, you had a chance to meet her, didn't you, in the course of your career?
Yeah, I did. Following my clerkship, I was selected to be a Women's Law and Public Policy Fellow through Georgetown. It's a fellowship that was created to be a pipeline for women's rights advocates and attorneys. And it was started by Ruth Bader Ginsburg and other people who worked with her at the ACLU Women's Rights Project, and very prominent women's rights lawyers in DC as well. And so I served on an advisory council and helped plan an anniversary celebration for the fellowship program. And Ruth Bader Ginsburg was our keynote speaker. And my mom, who really was of the same generation, born just a few years around Justice Ginsburg, really wanted to meet Justice Ginsburg. My mom had been a trailblazer herself and had faced a lot of sex discrimination as well in her career. And she wanted to meet this woman who had had such an impact on the law. So that's a very special memory for me when I was able to meet Ruth Bader Ginsburg and introduce my mom to her at the same time. And it was, you know, she was an inspiration to me, obviously. She not only set me on this path that I'm on now to be a women's rights lawyer and law professor, but gave so many opportunities to other people to follow behind her. And I guess the other thing I'd like to say about that is, in part, that's also because she recognized the people who came before her. On her very first brief to the Supreme Court, she included the names of Dorothy Kenyon and Pauli Murray as co-authors of that brief to the Supreme Court, but they didn't actually write a single word to that brief. But they were amazing lawyers themselves, Pauli Murray was the architect for Brown versus Board of Education legal theory and legal argument, as well as an architect of gender discrimination arguments under the Equal Protection Clause. Both she and Dorothy Kenyon sat on the board of the ACLU and had been working on these issues for a long time. So Justice Ginsburg both recognized the people who came before her and made the path for people who would come after her. And I think that's quite remarkable.
Yes. Let's talk about her work as a litigator. This is before she became a judge and then a justice. As you say, she was director, co-founder, I guess, of the Women's Rights Project at the ACLU. Margaret, would you and tell us a little bit about how she pursued a strategy to expand the rights of women in our society?
Yeah, I first learned about this strategy back in the mid-90s when I had the pleasure of going to this wonderful event where Ruth Bader Ginsburg, along with Walter Dellinger, who was Solicitor General at the time, and Janet Reno, who was the head of the Department of Justice at the time, did a reenactment of the famous Myra Bradwell versus Illinois case. That was a case where Myra Bradwell tried to become a member of the bar of Illinois and was denied it. And there's quite a famous opinion related to that that said women really need to stay at home and not be part of the profession. There's more to that opinion. But at that event, at the end of the reenactment, and in the reenactment, Justice Ginsburg represented Myra Bradwell, and no surprise, Myra Bradwell won during the reenactment this time. But Nina Totenberg asked her a question, the famous NPR reporter who covers the Supreme Court. And she said, I've heard that the way that you got your roadmap was this. And what happened was in 1968, there was a man, Mr. Moritz, who had sued the IRS for barring him from being able to take advantage of the caretaker exemption to income tax. This was available to women who took their parents, but not to single men. It was available for widowers, but he was not. He was just a single man, and he was excluded because of his gender. He brought this case on his own, and then famously, when he lost, Ruth Bader Ginsburg's husband, who was a famous tax lawyer, Marty Ginsburg, was reading the sheets about what cases had been decided and saw this case and said to Ruth Bader Ginsburg, I think we should litigate this case together. So they brought the case up and won at the 10th Circuit on his behalf with a finding that it was in fact gender discrimination to exclude a single man from that caretaker exemption. And the government petitioned for cert to the Supreme Court. And in that petition, they attached as an appendix that every single law, federal law, that did some sort of discrimination on the basis of sex. And their argument was, if you are to strike down this caretaker exemption, look at the slippery slope that you are creating. All these other federal laws will have to be struck. And she famously then decided, that's the roadmap for my career. I'm going to take law by law by law and work on litigating those cases to strike them down and change the face of sex discrimination in the federal government.
And those laws fall like dominoes.
Yeah, exactly. And I think Chris has put in the chat the brief, and at the very end you can see all of those federal laws that they attach. Not a great strategy on the government's part, but this goes to Phil's point where maybe she was underestimated.
So Phil, you, as a litigator yourself, what tell you that so many of her cases that fought for women's rights involved male plaintiffs?
Yeah, again, as I say sometimes in my sports law class, I had Ginsburg right after Frontiero, and so she was right in the middle of doing this. And her biggest point was this was about fighting bureaucracy. Again, it's nice to talk about the big issues like feminism and equality, and she was all about being a tax nerd and if you look at her cases, I mean, it's all Social Security reimbursement and tax provisions and things like that. I mean, that's really what she was quite good at and quite an expert at, that ultimately came into the whole feminist perspective, really. But her perspective in litigating, she had a lot of male clients mainly because A, she hated presumptions, as I told you, and B, she thought that it undercut working women to have their spouses not get the same preemptions and benefits that women were getting for male spouses. So even though she was representing male clients, she always saw it as it's not just about the male client, it's really about the working women who are not getting the same benefit as working men are for their spouses. And again, as you say, they fell like dominoes once they all went. And the Justice Department didn't realize in '68 they had just destroyed themselves by giving her that perspective. But yeah, again, it's what. But she was really into, as Margaret was saying. I mean, she knew the tax code and all the Social Security reimbursement stuff, and that's what she did a lot of in the sex discrimination course I was in. Was kind of revealing all these hidden presumptions in the massive statutes that are Social Security and a tax code and all of those kind of things.
You know, talk about presumptions. The Ginsburg case, which she litigated that I remember from law school, is Craig versus Boren.
Mm-hmm.
Oklahoma had a different minimum drinking age for men and women. They assumed that women were drunk quicker, I think. And it was all based on stereotypes and challenge that. So she becomes a judge first on the DC Circuit.
But wait, Ron, before we move on, can I just clarify one thing,
Sure.
just for people who may not be familiar with her law that she helped to create? Prior to the work that she and her colleagues were doing, if there was gender discrimination being enacted by the federal government or by a state, it was being reviewed under what's called the rational basis review, meaning, is there just some reason why this law is a good reason? And it might be as easy as administrative convenience or based on some assumption, presumption, or stereotypes. What her litigation helped to do is to craft a new standard, an intermediate scrutiny standard or a heightened scrutiny standard under the case that she decided as a justice, the VMI case, that required a more searing review of the government's rationales for creating two categories based on sex. And so, for instance, when in Frontiero, they were saying men who are in the military are able to have their wives engage in housing benefits that we give them. We're not going to provide that to females who are in the military because men don't need women to support them. There's the stereotype that need to be struck down, that women can in fact support their husbands and can be full-fledged members of the workforce, and men can be dependents and caretakers of their family. And so creating that intermediate scrutiny meant that the government had to have a legitimate reason, right? And the means had to be substantially related to that legitimate reason and had to survive a heightened level of review. That's still less than the review required for, say, racial classifications. She was, in fact, arguing that it should be up to strict scrutiny and didn't quite get there by the end. But that's a very important change in the doctrine.
That's huge. And as you say, it was her advocacy that got us there. And then she becomes a judge and gets to apply that standard of review. And then she gets to write opinions. And there's almost a seamless transition from her work as a litigator to her work as a judge that enables her to eventually decide a case like, is it Virginia versus United States, the VMI case?
Yes, yeah. United States versus Virginia. Yeah, in that case, VMI was an all-male institution, and the justification for being all-male was that it was a military-like school, and so they had things like a rat line and strict enforcement of rules that were quite physically punishing. It had gone up to the Fourth Circuit being challenged as sex-based discrimination and then was remanded to the district court. The VMI then created a separate institution called VWIL, Virginia as Women Institution for Leadership. And here we have basically separate, but trying to argue that they're equal, almost Plessy versus Ferguson in the race area. And it went up on appeal, and Justice Ginsburg wrote that decision. It was I think it was a 7-1 decision with Clarence Thomas recusing himself. And there we get a heightened level of scrutiny. So even more than the intermediate scrutiny we had before, and saying that you cannot rely on generalizations to exclude women from this. Now, maybe an average woman can't do all the physical work that's necessary to be a cadet. Maybe they can't withstand the rat line and this grueling physicality, but some can. And you can't exclude people based on a stereotype that everyone in a gender can't do that. And so you need an exceedingly persuasive justification if you're going to have a gendered biased admissions policy. And she also compared the fact that VMI was quite noted for its alumni and the amazing opportunities they gave to their students, and VWIL could not compete with that, obviously, as a new institution with a more limited approach to the education. So that's a very, she talks about you cannot rely on overbroad generalizations. This is the capstone of her work and what she was talking about to Phil when he was a student in her class.
Right. So let's talk about Justice Ginsburg as a role model. We now take for granted women on the Supreme Court. When she was serving, there were 3.
We do.
Well,
you know what Ruth Bader Ginsburg said? When will there be enough women on the Supreme Court?
When there were 9. Right. But we've seen others, Justice Sotomayor, Justice Kagan. But at the time that Justice Ginsburg is appointed, she was only the 2nd after Sandra Day O'Connor. Dionne, what did it mean to you as a young female lawyer, kind of coming up in the profession, to see Justice Ginsburg elevated to the Supreme Court?
Well, first of all, it's exciting because I love civil procedure, and it's exciting to see somebody who likes a dry subject like that, who has such a passion for it. But I have a Ruth Bader Ginsburg action figure on my bookshelf. I bought one for my daughter. She's not interested in law at all. But what Ruth Bader Ginsburg stood for, having a family and being at sort of the highest level of excellence in her career is something that I think I know I aspired to, and women I went to law school aspired to. And so, it wasn't just a pop culture thing. When you see it, you believe you can be it. Even if we're not going to be on the Supreme Court, we can achieve the balance that you can be excellent in all that you do. And I think she really stood for that. And that's what I took away from it. And so I proudly display my action figure.
That's great. And I think she was proud to be that standard bearer. Phil, you spoke about the fact that she came to Toledo Law School. She was a very public justice. She went to many schools and public gatherings, right? I mean,
yeah, she was. But interestingly enough, kind of the last person you would think was going to become a famous cultural icon. I mean, the words I would describe her was quiet and shy and unbelievably modest. I mean, she was always, she spent a lot of time in Toledo. She actually spent 2 days there. And that was kind of when Notorious B.I.G. was just kind of starting, about 204, 205. She was always kind of surprised by it and saying, I just kind of do what I do. And it goes that way. But but she was, and she carried herself amazingly well. Again, as you know, she was friends with Scalia. And I laughed at her once because I hosted Scalia 3 times. I said, boy, okay, you can dish him all night on intellectual matters, can't you? He just smiled and said, we have interesting discussions. But she was one of the most amazing minds I've ever met and talked to in terms of just knowing things.
I would recommend to our guests to get a sense of Justice Ginsburg as a person, both the documentary that came out recently, RBG, and also the feature film, the Hollywood film on the basis of sex, which really gives you a sense of the very special marriage that she had with Marty Ginsburg, as you said, Margaret, a fine lawyer in his own right and a great champion of hers. Famously, he was her best advocate when President Clinton was deciding who should receive his first Supreme Court appointment.
And Ron, to compliment Dionne's bobblehead, if you want to be a true Ginsburg follower, her favorite drink was Campari and soda. Anybody wants to have a drink in her honor, Campari and soda she drank wine, but Campari and soda is what she really wanted when she wanted to relax.
Well, we should toast her. We'll be able to do that now. Let's go back to civil procedure, Dionne, because I feel like you've been ready and raring to go to tell us all about those procedure cases. She was influential in that field, wasn't she?
She was tremendously influential. I think she wanted to be. I mean, I think she's best known, obviously, for what Margaret and Phil are talking about, anti-discrimination and equality. But I think about 25% of her opinions on the court were in jurisdiction and procedure. She authored many of the court's most important opinions in this area. She took pride in it. She once said she wished she could have authored them all. And so if you are teaching procedure, if you're a student of procedure, if you're a litigator, Ginsburg opinions are a map. Really, she did an incredibly effective job, and particularly in two areas. She, scholars have said that she really revolutionized subject matter jurisdiction. And that's something where, you know, that's access to the courts. And what she did, and she started it on the DC circuit, is she wanted to limit what was called jurisdictional, because of course, if something's jurisdictional and you miss a filing deadline or the signature's not on the right place and it's considered jurisdictional, that's fundamental, case dismissed. And so she did a lot and convinced her colleagues on the court to distinguish between what she called claim processing rules from the court's actual adjudicatory authority. She also was a big proponent of what is called resequencing, and again, students of civil procedure will be familiar with this. Subject matter jurisdiction was this sort of, you know, sanctified holy ground. We must decide subject matter jurisdiction first. It's the most fundamental, essential thing. And she was very interested in efficiency. She was pragmatic, she was functionalist. And so she decided cases where we can resequence. And two cases, the Marathon Oil case and the Sinochem case, she said a court, if it's more efficient to do so, can decide personal jurisdiction first or forum nonconvenience first. They can take that easy dismissal instead of getting caught in the weeds of a particularly difficult or potentially difficult subject matter jurisdiction inquiry. And she also famously wrote a unanimous opinion. She got Scalia to join her in a lot of these. In the Caterpillar case, again, students will be very familiar with this. She was a proponent of curing jurisdictional defects, that it's not fatal, it's not case over if we've invested the resources. And so she brought a tremendous amount of clarity to the idea that sometimes jurisdictional defects can be cured. And she also, I think, brought just an incredible clarity to personal jurisdiction. And then she took on sort of boring issues like claim preclusion. And a unanimous opinion in Taylor versus Sturgill. Students will remember that, right? The two guys in the Antique Aircraft Club. And she once again brought clarity to an area that was getting really, really messy in the lower courts and in litigation. And so I think it's a great contribution. She wanted to make that contribution, and that's what I think she gets less notice for. But anybody who's litigating on a day-to-day basis knows she made a huge difference.
Well, and those procedure cases ultimately determine who gets justice, who gets their case heard, who has their day in court. She's mostly, in the recent tributes, there was much more reference to her role as a dissenter, something of the great dissenter, as Elder Justice Harlan was sometimes called. What did it mean for Justice Ginsburg to be the great dissenter? Margaret, what's your sense of how she found her voice in dissent?
Well, again, I think the fact that she is such a clear writer, and when she also spoke from the bench, such a clear speaker. And this is really when her Notorious RBG popularity came about, because the dissents really gave voice to a lot of people who were upset with the decisions that were being handed down by the Supreme Court. So Ledbetter, in 2007, this is Lily Ledbetter, who had been working, and by the time she realized she was being paid less than than equally similarly situated men, it was outside the statute of limitations. And there was an argument that the statute of limitations should be renewed every time you're not paid equally, as opposed to the very first time it happens. She was in dissent on that case. It was found that there was not a viable Equal Pay Act claim there. And so she urged the legislature to Congress to fix this problem with the Equal Pay Act. And of course, it was fixed in 2009. So her dissent gave voice for then Congress to pick up the legislative pen and create a law to fix it. In Hobby Lobby, that's the case where a private for-profit company, right, that sells hobby essentials, said that based on their religious views that they should be able to deny, they wanted to deny access to birth control under the health insurance that they offered their employees. And that was upheld, and she dissented with a famous seer saying, okay, so now religion is going to be able to stop people from accessing birth control because it's against the company's religious beliefs. What about if it's against their religious beliefs to pay women equally? Or what about if it's against their religious belief to pay the minimum wage? So she said, where will this stop? Basically, where will the madness stop? And I think a lot of people heard that, and it really spoke to them because they were very concerned that this was going to be a big problem that needed to stop. And then the third, of course, is Shelby County, the 2013 case where Supreme Court threw out a key provision of the Voting Rights Act, a very serious issue. And she famously said, throwing out this provision because right now we're not seeing discrimination in the area of voting is like throwing out an umbrella in a rainstorm because you're not getting wet.
Yeah, very vivid quote. Phil, Margaret raised this question of, where the First Amendment is going to freedom of religion is going to bump up against civil rights, anti-discrimination laws. Do you see that as an ongoing discussion that the court is going to have to grapple with?
Yeah, again, the court has become more conservative, obviously, in the last 10 years, and they've allowed many more religious interactions between the religion and the state. So I don't see, obviously, Barrett, if she comes on, is not going to change that. Ginsburg was against it, but back to kind of where Margaret was, right? When the court was more liberal, Ginsburg wasn't as famous because she was just one of the majority. So she was just kind of in the liberal group. As the Roberts court became more conservative, her fame became bigger because she was seen as the leader of the four-person now minority. So it was an odd kind of juxtaposition. It was really the change in the court that made her more famous, because when it was liberal, she was just kind of one of that group. And then when the court went more conservative in all those cases that Margaret talked about and then some, Ginsburg became kind of, the voice of dissent. And that's how really she became even more popular in the cultural sense.
Right. Let me encourage the audience members to send us your questions. You've got the Q&A function in Zoom. We're very, very glad to convey those questions as they come. But in the meantime, let's just talk a little bit about reproductive rights, because that's an area of the law that may be shifting. What was Justice Ginsburg's role? She joined the court well after Roe versus Wade was decided, but there were subsequent decisions, Casey and other reproductive rights decisions that she played a role on. Margaret, how do you see that?
Yeah, she was in the majority in Whole Women's Health and June Medical, the more recent cases that struck down provisions that were trying to impinge access to abortion. But she didn't author one of those opinions. Of course, Casey was famously authored by Sandra Day O'Connor. But a tidbit I just learned recently, I just want to share, which is sort of interesting about this issue of Ruth Bader Ginsburg really being this leader in sex discrimination cases, and you don't think of her so much in the reproductive justice realm, though of course she was in the majority on those cases. One thing I didn't understand is that when she was being hired to be the co-director of the Women's Rights Project for the ACLU, that was because the executive director was able to foundation money from the Ford Foundation. And when the Ford Foundation gave them money for that, they said, you can work on women's rights issues, but not abortion. And so then the executive director had to go find other money. They got money from the Rockefeller Foundation, and they created a reproductive freedom project. And so here you see these two areas, and it was an interesting reflection that the former executive director of the ACLU had. Perhaps that was to Ruth Bader Ginsburg's benefit, that she was working on these sex discrimination cases, so she really didn't have this legacy of abortion cases when she was becoming nominated to the bench, which might have been hard since abortion is always such a hot button issue. And I thought that was really interesting, and I had not known that information before. And then you see that carried through. You know, she's famously authoring the VMI case, but she's not taking the lead on the reproductive, the abortion cases, though of course in the majority in supporting those cases.
Mm-hmm. I want to turn to the Barrett nomination, but just before I do, I'll give Dionne a chance to bring a little sports law into the discussion. I understand that Justice Ginsburg did author an opinion that was pretty significant in sports law. Is that right?
Yeah, she authored the unanimous opinion in NCAA versus Smith, which is the case that determined that the NCAA was not amenable to suit under Title IX. It was not a direct recipient of federal financial assistance. It's a pretty straightforward case. The reasoning makes complete sense in terms of the broader picture of what is a recipient of federal financial assistance. When we teach this case in sports law, we teach it as a case that's quite deferential to the NCAA. And in that case, we have a woman who was fighting for greater eligibility. The NCAA had denied her a waiver to continue playing. It went all the way up to the Supreme Court, and Ruth Bader Ginsburg authored the decision that upheld the NCAA's position. Not to say that she didn't get it right, but I think to the extent that people think of Ruth Bader Ginsburg as this sort of overly liberal, legislating from the bench kind of justice, not so at all. I think NCAA versus Smith would have given her a terrific opportunity to be even more aggressive. I think there was an argument that the NCAA could have been held subject to Title IX, and she played it straight. She was not activist, and so I think it's an interesting note on her legacy.
Yep. So turning to the Barrett nomination, which is pending in the Senate Judiciary Committee, we have a question from one of our guests. What do you think Justice Ginsburg would say about the Barrett confirmation process? So let's first talk about the process a little bit. I'll take off my moderator hat and tell you that I think this is a confirmation process that should not be happening. When Justice Ginsburg passed away, I was inspired to write an op-ed right away insisting that there not be a nomination and a confirmation, because we're in the middle of an election, because the Republican majority had denied President Obama's nominee, Merrick Garland, a hearing and a vote for almost a year in 2016 at the end of President Obama's term. And it just seemed to be kind of raw politics to try and jam this through. So that's what I thought of it. But what do you think Justice Ginsburg would think of how this is going? Phil, what do you think?
I think she would think exactly what you said. She would think it's raw politics, and that's where we are in this country. She was pretty much a realist. I don't think she was deluded or naive about where politics were going. I would say I wouldn't think she's ecstatic that Barrett would be her successor, but I think she would understand that the Republicans have the power and they're going to wield it, and that's pretty well all they care about. Again, it's amazing that in 4 years, Trump is going to get to put 3 people on the court. That's a lot for 1 4-year term. But by my lights, he should have gotten 2. Either he shouldn't have gotten the Garland one, and or shouldn't do this one. But in any event, I think she'd be realistic, and they all know what the confirmation process is going to be like, and if they're going to exert raw power, they were going to exert raw power. I suspect that's what she would have said.
It certainly looks like Judge Barrett is on her way to becoming Justice Barrett. We'll see if anything changes in these coming days. But let's say she does get on the court. What is that going to look like? Let's ask you all to look at your crystal balls and tell us whether Roe versus Wade is on the dustbin of history. Dionne, do you have a sense of whether the court will take that dramatic step?
Well, I think we all have a crystal ball, Ron. I think we all know where Roe versus Wade is going to go. I think the more interesting question for me is what happens when it does? Do we rely on the courts anymore, or do fights go to state legislatures? And is it beyond Roe versus Wade? Are there other cases where there are things that we have learned to, in our daily life that we count on? What's going to happen there? I think the other thing is that of all the Roe versus Wade's or Second Amendment cases, the types of cases that get talked about, what does she do in the types of cases that make up the rest of the court's docket? And I think there's a story there as well.
Margaret, let me ask you the question that's posed in the Q&A. With the overturning of Roe versus Wade seemingly imminent, the questioner says, do you think it's possible that someone will pick up Justice Ginsburg's theory of arguing under the Equal Protection Clause rather than the Bill of Rights privacy theory? Is that a road that we might see some justice or another travel?
Well, certainly that's been a critique of Roe versus Wade because it was based on the right of privacy, which of course was first created with the Griswold case striking down a law that prohibited married couples from using contraception, birth control, and famously was created from a penumbra, right, of the amendments to the Constitution, the Bill of Rights. And so if as Judge Amy Coney Barrett says, she is a textualist and an originalist. And when you look at the text of the Constitution, there is no right of privacy written in there. It's coming through the shadows of what's implied from things like the Fourth Amendment or the Fifth Amendment and so on and so forth. Equal Protection Clause is, of course, written in the amendments. Now, it doesn't say that it's specifically related to gender. At the time it was passed as part of the Reconstruction statutes after the Civil War, which is why it took the litigation strategy of Ginsburg and others to get a recognition that gender discrimination deserves some level of scrutiny under the Equal Protection Clause. So while there is language in the Constitution to protect the equal rights, I have no idea. We don't have a record on Judge Amy Coney Barrett on interpretation of sex discrimination. We have like one Title IX case that's a statutory interpretation case. We have her joining in some dissents, but she's not written any dissents. I think there were 3 cases she had decided that touched on abortion. We really don't know. So I'm just really guessing, which is never a good place to be as a lawyer or a law professor. But as a textualist and an originalist, I think right of privacy is a very difficult thing moving forward. And I worry about even the Equal Protection Clause. It makes me think the fight for the Equal Rights Amendment is probably even more critical than ever, where we would then have strict language that talks about the equal rights based on gender in our Constitution.
Mm-hmm. Ron, I'll go against the flow here. My crystal ball says that she won't overrule Roe versus Wade. Dealing with the question, the Equal Protection Clause is not available in abortion because in a case called Michael M., the Supreme Court's held that pregnancy is a real biological difference, and therefore it can't be grounds for any kind of equal protection treatment. I think that Barrett is going to continue the Republican conservative perspective on the court of allowing the states to restrict laws, to restrict abortion law and letting those laws stand. That's where I think it's going to go rather than just an outright overruling of Roe versus Wade. Roe has 2 parts to it. Both of them would be hard to overrule. One is Roe basically is based on the substantive due process clause, the doctrine of substantive due process. If she were to reverse substantive due process, that would bring a whole bunch of other baggage with it outside the abortion realm. I don't think she's going to do that. The other argument in Roe that really matters is a fetus, a person under the 14th Amendment, and the Roe basically rejected that out of hand. Every court that's dealt with it so far has rejected it. If she would try to change that, that would make the law go way off in abortion. Then the states couldn't allow abortions at all because it would be murder. Again, I don't see either of those really happening. I think that she's much more likely to just allow states to have more restrictive laws, which will have the effect of limiting abortion in those states that decide to go that way. But I have some reason I don't think she's going to overturn Roe versus Wade. I think that they're pretty much too aware of the flashpoint of that and what it would do to women's rights movements. And from their perspective, it's less obvious to just allow states to do it, defer to a state legislature and do that, rather than there will be a crazy outbreak if Roe versus Wade is overturned. I don't think they want that, or I don't think she wants it.
Yeah. Well, it'll be a very different court. People have said essentially a 6-3 conservative majority. There are lots of areas of the law where that could be significant. Federalism. In the chat, in the Q&A, one of our guests asked this question: why shouldn't our system of federalism be restored? Why shouldn't it be Justice Brandeis's belief that the states are mini laboratories of democracy and allow a certain amount of balkanization within our country so that states consider the scientific fact that, using Justice Kennedy's opinion in King versus Maryland, DNA is proof of an individual person's identity, and therefore there's an individual life in the womb. That got a little bit complicated, but let's just deal with the first part of that. Are we going to see more deference to states in a court that includes a Justice Barrett? Would any of you see that develop?
I think you certainly will on abortion. That was, I guess, the point I was trying to make is she will defer there. Again, how widespread that's going to be is hard to say at this point. I see it more in individual things, but Ron, again, it's always interesting to me that people think that the Barrett for Ginsburg is going to change the court significantly. And we just said Ginsburg fame was a dissenter. So, I mean, most of the opinions are only going to go from 5-4 to 6-3. The ones that matter, Burwell, Ledbetter, Shelby County, Bush versus Gore. I mean, they were all 5-4 the other way from Ginsburg's perspective. So it's going to be 5-4 versus 6-3. So the court's a little moved conservative. That's what I guess I'm trying to say.
Well, of course, people are worried about Obergefell.
Right.
Yeah, I was just going to ask.
Right? Sorry, Ron.
Go ahead.
But these cases that are based in liberty, which is within the text of the Constitution. But for instance, Roberts in dissent and Obergefell might not have disagreed with the liberty interest of being married, but said that marriage is defined by a husband and a woman, not as Kennedy, who wrote the opinion in Obergefell, said that it was defined by two people. And so I think there's been a lot of discussion, and I'd love to hear what Phil and Dionne and Ron, what you all think about the future of LGBTQI rights in terms of marriage, and before that, right, Lawrence with the anti-sodomy, with the sodomy law being struck down and found unconstitutional, again by Kennedy offering the decision talking about liberty.
Dionne, Phil, are we going to see marriages dissolved? The Supreme Court overturns Obergefell?
I think this is one of the most interesting things to look at, even more than abortion. Barrett's personal view is that homosexuality is a sin as a conservative Catholic. Is she going to implement that? I think that's what a lot of the confirmation hearings were about. It was about gay rights. I don't know why, but I don't think she's going to. I think she's going to allow Obergefell to stay good law. But again, I have no particular reason for thinking that, aside from constant statements she's making about, I will not let my religious views influence my views on the court. As I'm reading that, I think that's about gay rights, because that's the one that is the kind of the hot button conflict with her view is her religious views.
I mean, it'd be pretty hard to imagine, after the court has deemed marriage equality a constitutional right, and as I say, many people now have gotten married under that authority, that could change. I mean, the courts must be mindful of the practical consequences of their decisions, right?
I agree.
Ron, I also think the federalism question is an interesting one. One of the things Ginsburg commented on, again, this is in the area of civil procedure, but I think it's instructive. I don't want to put the participants to sleep with a recitation of the Erie Doctrine, but in a lot of Erie cases, the conservatives or the conservative majority would write and sort of privilege federal law over the states, right? And Ginsburg would say, where are all the federalism people now? I'm dissenting in an Erie case and think we should be deferring to the states. So in lots of areas, the typical conservative liberal split that we think of, federalism can cut it in different ways. And I think Ginsburg in some speeches, within the last few years was really talking about that. And so I think that'll be interesting as we spill out beyond abortion.
Can I just say one more thing on the LGBTQIA, which is the difference between the Constitution and statutory interpretation. So Justice Gorsuch, also a textualist, he authored the recent decision in Bostock versus Clayton County, which found that the sex within Title VII, which prohibits discrimination on the basis of sex and other classes in employment, that sex included gender identity and sexual orientation. And that was through a textualist interpretation. So textualism with statutory interpretation, that could have different outcomes than the Equal Protection Clause or the liberty or the right to privacy type of constitutional textualism interpretations.
I think one of the interesting things about Judge Barrett is her writing suggesting that she thinks stare decisis isn't necessarily a powerful force. She's willing to overturn precedents that she believes were wrongly decided. So whether they would go back on Obergefell, there might be many other precedents in the Supreme Court canon that would be vulnerable here. Is this going to be open season on precedent?
I don't think so. Again, people who think they're appointing conservative justices have consistently been disappointed over time. Earl Warren was supposed to be a conservative Republican California governor appointed by Dwight Eisenhower. Again, not always, but usually predictions of extreme conservatism are wrong. Again, maybe Clarence Thomas, an exception. I guess Scalia didn't disappoint, maybe Alito, but I mean, it usually happens that people become Supreme Court justices and they become more kind of institutional in their perspective. It's easier to write that, I'm going to ignore stare decisis when you're not a Supreme Court justice than when you're actually on the court and somebody's telling you, God, you know what you're overruling here. Look at all the great minds that were before you. That it takes on, I think, a different perspective when you're actually on the Supreme Court, whether you're left or right. And I think you become a little more respectful of stare decisis when you're on it.
Well, let's take it back in these last few minutes to Justice Ginsburg. What is her place in history? The court may move on, may move in a more conservative direction, but she has a body of work. How will she be viewed by historians? What will we see as her role in the story of America? How about we start with Margaret?
Well, of course, her story ended with her as a justice on the Supreme Court, but began, as we talked about, as a women's rights lawyer. And this is a story of someone who was single-minded, who was patient, who was strategic, who was a team player, all the way through the Supreme Court with her famous friendship with Scalia, being able to work well with others. So her legacy is singular in that she really paved the way for equal rights for women. And there's obviously her legacy is one of formal equality for women, being treated the same as men. And as Phil pointed out, I think it was the Godolga case, actually, Phil, not more, but that said because women were pregnant, not all women are pregnant and therefore the Equal Protection Clause couldn't apply, there's still more work to be done on what we call substantive equality, these places where women are different. And of course, biologically different, from pregnancy to breastfeeding to other areas. So her legacy is that she made great progress by being this excellent lawyer and justice, being careful, being strategic, and being patient, and making real change, long-lasting change.
Dionne, you'll be teaching her civil procedure class, civil procedure cases for many years, I assume. Is that a portion of her legacy?
Absolutely. And I think that's the portion of the legacy that's probably most likely to stand. A lot of her opinions, as I said, were unanimous opinions joined by her friend Justice Scalia. And so I think they're sound. I think they're going to stand. And I don't think they blow with the winds of, different interpretations, so to speak. But I think her legacy can be summed up for me in terms of her place in history with, there was a viral tweet after she died, and it said, if you're a woman and you used a credit card today without your husband's permission, thank Justice Ginsburg. And so I think there were these things that we take for granted, these day-to-day, daily life. I think it goes back to Phil's point that, deep in the weeds of Social Security and tax, here was a woman who really made a difference, and it has an impact on everyday lives. And so I think those are the things that will historically be quite significant.
And let me ask Phil, and really all three of you, will she remain an inspiration to our students? As you say, she kind of acquired this status of cultural icon somewhat later in her career. Is that going to survive in the years ahead? Will law students be talking about the notorious RBG? Phil, what do you think?
Yeah, her status, to me, is more than just liberal. I mean, her status is about women and about women empowerment, and ultimately about male empowerment, because, men can't be equal unless women are equal. And I think that transcends the liberal or conservative label. And I think that's what will cement her legacy for a very long time. My personal view is that 20 years from now, people are going to be citing her dissents as maybe this is how it should have been. We have famous dissents from the 100 years ago or 60 years ago, where everybody said, "Oh, that dissent was right." I suspect that 50 years from now, people may be looking at their dissents in some of those more high-profile cases and saying, "Boy, she was right." But again, ultimately, I think her fame is ensured by the fact that whether you're liberal or whether you're conservative, her contribution to gender equality and men doing more work in the home and women being more liberated, that transcends whether you think I'm just like her because she was holding the liberal flag. And I think over time that's what she's going to be known for.
I mean, I think very few Supreme Court justices are well known to the public. It's one of 9. They're all wearing black robes, but there's Thurgood Marshall, who stands out. And when we all fly out of BWI, we're flying out of Thurgood Marshall Airport. And he's there because of a career first as a litigator and then as a justice that was so meaningful to the progress of America. And Ruth Ginsburg, I think, stands alongside him. Slighter, less physically imposing than Thurgood Marshall, to be sure, but in her way, she was just as large and powerful and influential, don't you think?
Absolutely.
Last words?
Absolutely.
I'll just say that I have been so touched sharing stories about how RBG inspired our students. Hearing from them about what she meant to them has really been amazing and eye-opening to me. I knew there was this cult icon status, but I didn't know how deep and important it was for everyone. Not only the litigating she did and her work on the court, but also what she stood for, as Dionne talked about, being able to be an amazing lawyer and have an amazing family as well.
Well, this is great. Let's stop there. Margaret, you got the last word. Thanks so much to our panelists, Professors Margaret Johnson, Dionne Koller, and Phil Closius. Thanks to those who joined us as guests and asked some very good questions in the chat. And I invite you all to continue to pay attention to sign up for these webinars, UB Law in Focus. As I said, there's one coming up on family law and structural racism. So lots of interesting topics still to address in the way that we can be together under public health circumstances. We're going to keep plowing ahead on these Zoom webinars, connecting with each other and talking about the issues of the day. Thank you all very much. Have a good night.